Ladies and gentlemen of the media, this is a statement of the Parliamentary Minority Caucus on the judgment of the High Court, Accra, in the case of the Republic versus Bernard and Buasiako and Akonta Mining Limited. Ladies and gentlemen, some judgments settle a case, others test a nation. Ghana will be judged in years to come, not by the sentencing handed down in Accra yesterday, but by how faithfully we defended our Constitution in the aftermath. We speak today on behalf of the Minority Caucus in response to the judgment convicting the Ashanti Regional Chairman of the New Patriotic Party, Mr. Bernard Buasiako, popularly known as Chairman Wontumi, and Akonta Mining Limited. We speak not as advocates for one man, but as custodians of a constitutional order that must apply equally to every Ghanaian, regardless of political color. The New Patriotic Party has already issued its own statement on this matter, expressing profound disappointment, insisting no evidence showed that Wontumi unlawfully assigned his mineral rights, and calling the conviction a travesty of justice. We do not repeat that statement here. We in the minority, we do not repeat the statement here. And nothing we say duplicates it. We speak instead for our own constitutional duty as the minority in Parliament to interrogate the conduct of the state wherever the public interest demands. Before we turn to the law, a word for the human beings at the center of this, to Chairman Wontumi, to his family, to the New Patriotic Party in the Ashanti region, and to our party at home and abroad. You are not alone. And your pain is a shared one. Grief and anger are natural in a moment like this. The best tribute we can pay Chairman Wontumi right now is a resolve. The minority will do whatever is lawfully and properly within its power through Parliament and through public advocacy to see that justice is done and that the defects which have robbed the judgment of its legitimacy are corrected. Let us be equally clear about where we stand on the law itself. We hold the judiciary of this republic in the highest constitutional regard. We do not impugn Justice Kokuvi Tay personally, and we invite no one to disrespect this judgment. We support accountability. We support the vigorous prosecution of illegal mining, a scourge that has degraded our rivers and endangered the livelihoods of generations yet unborn. We seek immunity for no one on the basis of the party. But 4 serious defects run through this case, and each deserves nation's full attention. First, the denial of a counsel of choice. We understand that judgment was delivered despite the absence of Chairman Wontumi's lead counsel, whose office had notified the court of a prior professional engagement abroad. Article 19 of our Constitution guarantees every accused person a lawyer of their own choice, and that guarantee may only be displaced in the most exceptional circumstances. This country once built a decade of political outreach around exactly this question. In the trial of Mr. Chachukata, that case ended in 2016 with the Court of Appeal acquitting Mr. Chikata and condemning the trial's conduct by name as a miscarriage of justice. If that standard mattered in 2016, it matters today, regardless of whose name sits on this charge sheet. Second, the refusal to refer serious constitutional questions to the Supreme Court. Article 130 reserves constitutional interpretation for our highest court alone. Instead, the trial judge decided for herself that Section 99 2B of the Minerals and Mining Act was, in her own words, clear and unambiguous. Our own Supreme Court has already condemned exactly this maneuver. In the Zenato case of 2016, the court quashed a high court ruling for wrongfully assuming jurisdiction over a constitutional question. It ought to have referred. The parallel here is exact, not merely similar, and on that authority alone, this judgment reflects a miscarriage of justice correctably on appeal. Third, and perhaps most vulnerable of all on the law, is how the court pierced Akunta Mining Limited's corporate veil to convict Chairman Wontumi personally. Since Solomon and Solomon in 1897, a company has been a person in its own right, separate from its shareholders and directors. Our own Supreme Court affirmed exactly the principle in Mokos versus Kuma. Veil piercing is permitted only where a company is a sham, a vehicle for fraud, or built to dodge an existing legal duty. None of that was found here. Akunta Mining was incorporated in 2010. Its lease was granted in 2021. The conduct alleged came later still. There was no obligation yet in existence for the company to dodge. What the court found was untidy governance, not fraud. And untidy governance is no license to erase a company's legal existence. Worse still, the judgment convicted Wontumi and the company separately on separate counts, using reasoning that treats them as one and the same. A court cannot dissolve a company to convict the man and then reassemble it, fully intact, to convict the company too. And all of it was unnecessary. If the evidence showed Wontumi personally directed unlawful mining, ordinary criminal law already covered him as a principal or an accessory without touching the company's separate existence at all. Left uncorrected, this reasoning threatens every founder-led business in